Bismillah Rahmanir Rahim viewers. Uh, Today we are going to Islam and international relations. And within the topic, we'll be discussing concepts of international relations, where we'll try to um, explore the different uh, concepts within the House of Islam. For example, jihad, refugees, um, treaties, peace, asylum, international law, humanitarian law, human rights, Islamic political economy, democracy, sovereignty, and ummah. Now, to start with, international relations under Islamic law or Sharia were traditionally governed according to the definition of the concepts of war and peace. However, this principle diminished following the downfall of Islamic Ottoman Empire in the earlier 20th century and the establishment of nation states. Now, nation states here does not mean that nation states did not exist before the decline or demise of Ottoman Empire. They do existed. However, after the breakup of Ottoman Empire, a new world order was established, where the Ottoman Empire was broken into various small states, most of which became the colonies of different European countries. More recently, this discussion of these concepts has been revived due to the rise of militant groups that are operating not only in the Middle East but the rest of the world as well. And all those militant groups are then, in one way or the other, associated with Islam because the members of those militant groups belong to the religion of Islam. In late 1960s, Islamic groups or the militant groups adopted a fundamentalist interpretation of the concept of war and peace. In particular, such non-state actors issued decrees claiming that they are in war against the world to defend what they called the House of Islam. However, various Muslim scholars expressed disagreement with such a fundamental perspective. These scholars have held conferences and published books and articles in an attempt to reach a common interpretation of the term the House of Peace and the House of War under Islamic law. Today, lecture is prepared from different scholarly writings for the purpose to provide an understanding of conceptual differences between Islamic legal schools in interpreting the issue of war and peace. I will also present the views of Muslim scholars regarding the characteristics of individuals who are recognized as Harbis or enemies under Islamic law. Finally, the different opinion of Muslim jurists related to motives behind declaring jihad, which literal meaning is struggle. The motives behind declaring jihad against another country. During the period starting from middle of 17th century, Islamic conquests of vast areas ranging from eastern shore of Atlantic to Afghanistan forced Muslims to contemplate international relations and the concept of war and peace. At the time, the Islamic empires such as Umayyad and Abbasid dynasties established rules regulating the relationship between themselves and their neighbors, essentially dividing the world into two groups, that is Darul Islam, which is the House of Islam, uh, those areas which were governed by Muslims according to the norms of Islam. And Darul Harb, that is the house of war, uh, these were those areas where Muslim rulers did not have any control. Uh, by saying this, I mean that those countries were not ruled by Muslims. They and Islam, to be very specific, did not govern those areas. However, there was a population of Muslims living in those areas. Those countries that were termed as the House of Islam also had a population of non-Muslims. And similarly, the countries that were governed by non-Muslim rulers, they had also population of people belonging to different faiths or religions. Later on, when the Islamic Empire began to enter into treaties with neighboring kingdoms, the concept of Darul Aman, or the house of safety, was introduced as well. According to Muslim scholar Dr. Wahab al-Zuhili, there is no precise definition of Darul Harb and Darul Islam in the existing religious sources of Quran or Sunnah. So most Muslim jurists state in their writings that the interpretation of these two concepts is debatable. Islamic scholars consider these concepts subject to ijtihad, which is an effort to achieve an independent interpretation of problems that are not dealt with by the Quran or Sunnah. Now, if we are to look at the Darul Islam, Muslim scholars' definition of Darul Islam is not similar. It varies. According to some, a country is classified as Islamic when that country either relies on Sharia as the basis of its legal system, or incorporates some aspects of Sharia into its secular system. Saudi Arabia, the Gulf states, Pakistan, and Iran are some of the examples that are considered to be examples of having adopted these approaches. Another group of scholars believe that Darul Islam also include countries of Muslim majorities, even if the government do not incorporate Sharia into their legal system. For example, Egypt, Syria, and Turkey. And a third faction of Muslim scholars maintain that a territory cannot be labeled as Darul Islam if the Muslim population living there enjoys peace and uh, does not enjoy peace and security. Or we may say that they maintain that a territory can be labeled as Darul Islam if the Muslim population there is having freedom of religion, they are in peace with each other. By that I mean with the followers of other religions, they have freedom of religion, and they feel secure in that state. So the third faction of Muslim scholar is of this opinion. Now, the house of safety or Darul Aman. The concept of Darul Aman is manifested in verse 92 of Surah Al-Nisa, the chapter on women in Quran. This verse commands Muslims to honor the covenant that was agreed upon with non-Muslims. Dr. Abdul Jalil Sajid, a current Islamic scholar, defines Darul Aman as a territory or a country that has concluded treaties of peace with countries in Darul Islam. It appears that the only treaty that meet this definition are those that cover the areas of trade and mutual cooperation. The history of Islamic Empire provides rare examples of Darul Aman, such as trade agreements between the Nubian Christian kingdom and Sunni Muslim Abbasid Empire during the 11th and 12th century. Now, here I would like to explain one thing, that despite categorize the world into these two uh, categories, Muslim states or the House of Islam was also in diplomatic relations with non-Muslim countries of the time. As they were trading with them, they were having peace negotiation or peace treaties with them of not engaging in war with each other. So in that sense, we can say that it is also something that we may say link Islam or Islamic society or a country ruled by the norms and principles of Sharia has association or is linked with international relations. They cannot be segregated from this discipline, because they have a system, a hierarchy of rulers. Most of them are democratic states. Some may be monarchs or authoritarian states at present. Even in the past, there were countries that were democratic in nature, and there were authoritarian and monarchies as well, but they were conducting trade relations with each other, signing treaties with each other. So Islam, House of Islam, is part and parcel of international relations. It can be studied as an important subject of international relations. Coming to Darul Harb, or the House of War, Muslim scholars provide a number of definitions for what they call Islamic law, Darul Harb, under the Islamic law. One school of thought, including the one school of thought that we may say that they are the follower of Imam Abu Hanifa, the founder of Sunni Hanafi school of Islamic jurisprudence, mention that labeling a territory or a country as Darul Harb depends on the safety and religious freedom of Muslim in that place. As I just said, that country can be considered as Darul Islam, or a house of um Islam, based on the uh, Muslim population treatment in that country, where they have equal rights, where they are not discriminated. So here in this case, labeling a territory or a country as Darul Harb depends on the safety and religious freedom of Muslims, and then place in that place. And if Muslim living in that non-Muslim territory or state are not allowed to practice their religion freely and do not enjoy safety in certain territories, then it is described as Darul Harb. Another group of scholars, led by Yusuf al-Qaradawi, identifies non-Muslim states, countries that attack or conquer Muslim territories as Darul Harb. Now, jihad within Islam. Uh, the word jihad means uh, has its root in the word jihad, which means struggle. So whenever there is a debate on jihad or discussion on jihad, uh, most scholar would term it as struggle, but not war. However, in the Western writings, we see that the term jihad is always associated with war, uh, and a war that is uh, fought by non-state actors, which is not the case if we study deeply the concept of jihad. So Muslim scholars were faced with the need to clarify various questions and concept following Iraq invasion of Kuwait in 1990. In particular, the main question was whether or not declaring a war or jihad against a Muslim territory or country is permissible according to the Islamic law. Now, that is a very big question mark on uh, the concept of jihad or war, because jihad is considered to be fought against ill, or jihad is struggle against ill in the society. That can be verbal jihad, that can be fought through uh, coercion or telling the other not to engage in that ill process, or it can be a war if the first two steps of jihad are not enough to contain the enemy. So many Muslim scholars responded to this query by condoning the concept of waging jihad against a Muslim country such as Iraq attacked another Muslim country. The term Darul Harb goes hand in hand with the term jihad. One of the Sunni jurists, and that opinion, I believe, is also shared by many of the Western scholars, that Darul Harb or jihad uh, goes hand in hand with each other. So the Sunni jurists of Maliki school of thought, Ibn Arafa, defines jihad as warfare waged by Muslim against non-Muslims for the purpose of elevating the word of God if the enemies are against God's presence, or as retaliation for the conquest of a Muslim territory. So that comes in defense of their faith as well as their country. So most scholars belonging to this school of thought are of the opinion that it is either a war against the country that is a threat to their religion or is a threat to their security. So a war can be termed as jihad. It appears that many Islamic scholars support this principle by referring to the verse in the Quran that states, and I quote, "Permission to fight has been given to those who are being fought because they are wronged, and indeed Allah is competent to give them victory." Uh, Viewers, if we examine the recent decades, Muslim jurists have also sought to define groups of individuals against whom jihad could be waged. As a result, jurists have reached different interpretation of Harbies or enemy fighters. The first group of scholars represented by Sheikh Ali Juma, who was the former Egyptian Mufti, defined Harbies as individuals belonging to a military force sent to launch an assault against a Muslim territory or country. Sheikh Ali Juma also prohibits Muslims from joining non-Muslim armies sent to fight other Muslims in a Muslim country. And the example of that can be the many countries within the Middle East, like for example, Syria, Egypt, Lebanon, or even Iraq, where the West and its Muslim allies were hand in gloves with each other. They were fighting side by side with the Western countries against Muslim countries. So another group of Muslim jurists is of the opinion that fundamentalists that are in a way termed or described as fundamentalist. They described all the citizens, whether civilian or military, of a country that has sent its troops to fight Muslims. They justify this concept by stating that those citizens have democratically elected their governments. Therefore, each of them individually is responsible for the decision of their government to attack a Muslim country or a territory. This perspective is widely condemned by many Islamic scholars across the world because many of the non-state actors are attacking countries, whether they are Muslim countries or non-Muslim countries, and the casualties or the victims are always the innocent people, the population of that state which is under attack. Now, if we are to conclude this topic, Islamic law regarding international relations divides the world into three categories that we just discussed. That is House of Islam, House of uh, Darul Harb, House of or Darul Aman. Uh, while there's no clear definition for any of these concepts in either the Quran or Sunnah, over time, the Islamic empires from the Umayyad to the Ottoman Empire um adopted the concept when dealing with neighboring non-Muslim entities. However, it happens that under current international law regulating the relationship among states worldwide, the Islamic states have largely moved away from the implementation of the concepts of war and peace that had previously been applied under Islamic law. Today, the principle of Darul Islam and Darul Harb are no longer incorporated into the legal systems or international relations of Muslim states. However, Islamic militant, rather, I would say that militant non-state actors, as I earlier mentioned, like Al-Qaeda and various other non-state actors, apply their own version of fundamental or fundamentalist interpretation of these concepts and use them as a justification to launch terrorist attacks on not only Western countries and their interests throughout the globe, but they are also targeting Muslim countries and the population within those Muslim countries. So these actions have given impetus to many Muslim scholars to discuss the definition of these concepts with the aim of reaching a universal consensus regarding the principles of Darul Islam and Darul Harb under Islamic Sharia. With this, ladies and gentlemen, we'll end today's topic here. Your comments are welcome. Please like and subscribe to my channel and hope to see you for the next discussion. Khuda Hafiz.